from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome back to our series entitled Know the Law. For you who have been watching in previous weeks, you know that we've had a series of programs on particularly trying to be helpful to you about different questions in law. In the past, we've dealt with such programs as bankruptcy and tenant-landlord laws. On today's program, we're going to address the law and public policy. The courts, both federal and state, have engaged in many very important decisions that address issues that are what we call public policy. We're very fortunate to have two attorneys from Coeur d'Alene to address this question who come with great expertise and knowledge on this subject. I first welcome to the program Scott Reed, who is particularly known for his work in public policy and such issues as the environment. And next to him is Norm Gissel, who's also worked in this area, and one of those areas would be civil rights. And gentlemen, it's a pleasure to welcome both of you to the program and to discuss what we have found to be a very stimulating and informative series.
Thank you, Tony.
And I'm very pleased to have on the panel today, first to my left is regular panelist Janelle Burke, who is an attorney in the state of Idaho, and she's also the law clerk to Judge Gary Heyman. And next to her is a member of the faculty at North Idaho College, Lloyd Marsh, from the Division of Natural Sciences. He visits us from time to time as a panel member. We're happy to have him here. I shall ask Janelle to commence the questioning.
My first question is going to be for Scott. We oftentimes hear people say, I just wish that the court would enforce the Constitution, or I just wish that the court would enforce the law. What do people really mean when they're saying that?
It's easier to say what people really mean than it is to explain what the court does when they get that message. People believe the law is very clear and believe that's what should happen one way or another. Court decisions, particularly appellate court decisions, inevitably reflect a great diversity of views over what should happen. And what exactly the Constitution means results in many, many controversial decisions, very close decisions. I think, Janelle, probably the classic case of let's enforce the Constitution according to what it means is in the segregation cases. Plessy versus Ferguson in 1896, the Constitution, the 14th Amendment, meant separate but equal. In 1953, Brown versus Education said it doesn't mean that at all.
And so the law, what you're saying, is elastic, too, to a certain extent. And public policy is set by what's happening at the time.
That's right. The public policy is, of course, set by the legislature or set by the administrative office, whether it's the governor or the president, but it's set always against a background which provides for public review through the court system. That's why we have our three-part system of government.
And Norm, is it generally, would you say, that this issue comes before the court when there is a question of first impression, we would say? That is, it's already not been decided. It hasn't already been decided.
Frequently, the Supreme Court or any appellate court of final resolution looks at a case of first impression. Supreme Court also looks at cases where one circuit, and I believe there's 11 circuits now, where one circuit or a series, 2 or 3 circuits will have a decision this way on a particular subject, and other circuits will have a decision holding in the opposite direction. And the Supreme Court's job then is to try and resolve and get a resolution that is nationwide on a particularly important problem.
Now, there are various components of a case that you're going to take up on appeal. You've taken up a case recently on appeal, as Scott has on many occasions, and there are components of that. What would you consider the components? The factual case, the law as it applies to that point, but then also some public policy matters. Can you kind of define for our viewing audience what those various components might be?
The factual expression of any case is the primary. In Brown versus Board of Education, which is the famous case that Scott referred to, the factual setting there was extremely important, and you would not have had that wonderful case had there not been a huge factual presentation that preceded the legal work on that. So the factual situation is absolutely important. Secondly, you have to have, if you're going to proceed in appeal on a constitutional question, you have to have a facially a good case to bring on a constitutional basis. So you have to have a lot of preparation for that. And certainly you're not going to bring a case where there's not a public policy argument to be made for your position. So there's the factual situation that the people find themselves in, the constitutional law questions and the public policy questions are all present in any good appellate case.
Lloyd Marsh.
I guess as a novice, you're going to have to educate me a little bit. As I understand it, public policy is something that's established by the state, I assume, to protect the rights of individuals or the rights of the state. Can you separate those for me? I mean, and how do we get to this appellate position? Has public policy been challenged when you're at the appellate level?
Absolutely. I could, in my own case, that Tony referred to was State versus Reed. In that case,
Not me.
No, there's a different Reed, R-E-I-D. Yeah, I'm not his attorney. I'm his friend. In that particular case, there was a public policy that had been articulated by the federal government and by the state government, and June Reed and myself disagreed with that public policy, and we thought that there was a second competing public policy that had been ignored, and we proceeded to litigate that case on a constitutional question, but we also wanted a good factual presentation so when the Court of Appeals, in our case, decided that question, that if we did in fact lose on the constitutional question, we would have a good factual presentation that we could argue from politically to show that there was two competing public policies, and then we would go to the state legislature and advocate based on the results of that case.
Could you fill us in a little more about the particulars of that case?
Yeah, I could consume the rest of the hour talking about that, and I'll rush through it. What we found is that there is a public policy throughout the United States that says that for those children on public assistance, if they have an absent parent out there that's working, that absent parent should contribute to the welfare of that child economically. Yes. Nobody disagrees with that. What we found was that there are extremely poor people out there, June Reed, one of those, who are not on welfare, but who have children that they're custodial parents of. And for the state of Idaho, in this case, to attempt to get money from her for the support of her second child, which was with the child's father, would cause an extreme hardship on this little custodial child that June Reed had. And the public policy question is what business does government have of impoverishing further very poor children? And there is no public policy to support that. So there is we had that competing argument, the argument that deadbeat fathers and whatnot should pay for their children who are on public assistance.
So in fact, we are in a catch-22.
Yes, there was a clash of public policies there.
All right.
I would like to go into what we call different interpretations of the Constitution by great jurists over the years, and those that I would describe as the strict constructionists of the Constitution, or maybe we call it literal interpretations, they see it, versus those who have a more loose interpretation, or one might call a more liberal interpretation. We've read about jurists and judges who argue back and forth. Courts don't make policy, they simply react to the policies, decisions in law from the Congress and the President or from the states. Scott, I'll direct my question to you. And others have said no, that there's major court decisions that are handed down that impact in the lives of people in policy as great or maybe even greater than laws passed by the Congress or the President. How would you react to these two schools of thought? And obviously, would like for you to give us some examples of court cases in which you think that it proves the argument one way or the other.
Well, the argument itself has some tenets that probably won't bear up. Strict constructionists are people who say, I am going literally upon the Constitution, but very frequently they will come into situations in which others are saying you're way off from the Constitution. That isn't the way it was written at all. I think what you end up with is often, presently, the most recent matter that's been discussed over a past number of years has been original intent in the Constitution. What did our founding fathers mean when they wrote the Constitution? And the problem with that is that often they weren't thinking about what we were thinking about when they wrote the Constitution. And what did the original founding fathers think about the rights of free speech on television is not really very clear from reading the Philadelphia Conventions in
Not very relevant when you deal with television and radio.
That's right. But that process is, there is a line there, and I think the justice on the Supreme Court at the present time, who is what might be called the epitome of a strict constructionist, is Justice Scalia, who believes that you look absolutely at the literal word and you don't go beyond. You don't go, for example, in the statutory history, you don't go into the rest of this sort of thing. And that's an ongoing debate at the present time, and it's a very interesting one because the results don't necessarily turn out to be liberal or conservative.
Let's talk about a couple of cases. I think you made a good point that no matter which side of the fence you might be on, there were so many things they didn't know about television, radio, and cars, and nuclear weapons, and et cetera. And so, but one of the magic aspects of the Constitution, many parts were written so flexible and vague that they can be applied to the present time. But can we look at 2 or 3 major U.S. Supreme Court decisions that really has impacted and affected the lives of all Americans?
Well, certainly. The Constitution, for example, is totally devoid, as originally written, about anything having to do with birth or women or any part of that. And it's not just devoid of anything about it. If you look back, unless you're a feminist reconstructionist, unless you look back into the 17th and 18th century, it isn't there. They weren't talking about it. But as life goes on, and no pun intended, but as life goes on, it became in the middle of the 20th century a matter of great importance as to what women's rights were, what children's rights were, and so we end up with some very remarkable decisions. Griswold versus Connecticut, that struck down a Connecticut law that banned the sale of contraceptives. That really changed the whole structure of what states could do in terms of controlling birth control. And then, of course, we have the famous or infamous, depending on your viewpoint, Roe versus Wade, in which the court determined that the states could not interfere with a woman's right to obtain an abortion. The one thing we're absolutely sure about is that that wasn't a subject of discussion when they were writing the Constitution.
Norman, I'd like to proceed on with this in the way that Scott has discussed it. How would you react to this statement that all branches of government, the legislative, executive, and judicial, make policy, both at the national and state level?
Of course they do, and they do it all the time. We just hope and pray that they do it wisely. One of the greatest cases is the case that Scott decided, Griswold versus Connecticut. It established this whole right of privacy and articulated a right of privacy that simply wasn't otherwise there. I think he had some vague references to the penumbra of this right, or it's like a shadow right that existed out there altogether. And much of the resistance, or much of our ability to resist government's intrusion into our most personal aspects of our lives is based upon Griswold case decided in the 60s.
I want to follow up with another question on this, and this may be an unfair question almost, in the sense that it's hard to make this determination. I mean in that sense. Scott and I were talking earlier about a number of major U.S. Supreme Court cases, and we've identified here today the 1954 case of Brown versus Board of Education, and again Plessy versus Ferguson back 1896. I know, Scott, you mentioned earlier that the Dred Scott case certainly might have been the most significant thing to bring on the Civil War, and there's others. From this historical review that you both have such an advantage on, do you think there is one U.S. Supreme Court decision that has been the most I wouldn't say important, but it's been the most impacting of any other decision we've ever had. Scott, I would start with you.
Marbury versus Madison.
Talk about it. Go tell them about it.
Norm, go ahead.
It is.
Marbury versus Madison was one of the very first cases that the Supreme Court decided. The Supreme Court decided that the Supreme Court was the final arbiter on who decides what the law means. So there was then three branches of government that had real power: Supreme Court, and the executive side and the legislative side.
And if we had not had Marbury versus Madison or a similar case, because it's not in the Constitution clearly that the court will interpret the Constitution, we might have had a very different system, or like the British, where the courts cannot interpret the laws of the Parliament or the House of Commons. Scott, would you seem to agree with Norm that that was the most impacting case, based on the fact that Marbury versus Madison and the Marshall Court were able to say they could interpret the Constitution, and it has prevailed. Is there any case since then that you think that has maybe changed the whole process more than any other case other than that one?
Well, let me say one more word about Marbury versus Madison. Marshall made the decision, and Jefferson said, well, he's made the decision, now let him enforce it. And of course you had to go through the process beyond that to finally say, yes, when the court makes a decision, the executive will enforce it. And the Brown versus Ferguson, of course, ended up with President Eisenhower finally sending the troops down to Little Rock, Arkansas to say, yes, those children are going to go to school. So you have to, though we have three separate entities in our government, we also have to have cooperation between them. It's always been difficult to do it. The case you're looking for, Tony, because I know how to answer questions when I get a leading one, of course, it's Baker versus Carr, which you have. Which you carried through every possible reapportionment case in Idaho and so forth, that obviously, since you were so deeply involved, had to be the most important case that was ever decided.
Well, you would say that just to get a
That was the case,
going.
let me explain a little bit. That was the case
sure.
in which coming out of Tennessee, they had a rural dominant legislature, and the determination was made that you couldn't do that you had to go one man, one vote. With all apologies to you, that's the language. It was one man, one vote, one woman, one vote, one person, one vote. It couldn't be, you couldn't break up your legislature, you couldn't break up your school district, you couldn't break up your county, you couldn't break up the rest of this based upon some other method than people.
It was really interesting that you make that note, because Earl Warren, who was Chief Justice of the Supreme Court during this most active period probably in the history of this country, and again with Brown versus Board of Education and that case and cases on right to remain silent and so forth, Earl Warren said in handing down that decision that he thought it was the most significant decision that court ever made, and they made some rather remarkable decisions, because he said that the heart of democracy was the right to vote. So that is an interesting commentary coming from.
Many people say we still have the same rotten government now that we had before, but at least it's a different way of voting for it.
And let's move on to Janelle Burke.
Well, this opportunity to talk to you a little bit about some of the cases that have arisen that are really important, we can't pass up that opportunity. One of the things that's really important to our form of government is the Bill of Rights. And so I'm just going to ask about some of the various amendments and let you sort of free flow cases that come out of that amendment. For example, First Amendment, freedom of speech. Scott, what comes to your mind? A recent case that's
New York
been
Times
important.
versus Sullivan, I think, was probably the most important from a publishing point of view in First Amendment rights. In this particular case, again, it's part of this segregation civil rights movement that came down there. A sheriff, as I recall, from Alabama had sued the New York Times because of an ad that was run in the New York Times by the NAACP, setting forth things that had happened in Selma and so forth. Tried it before an Alabama jury, got a multi-million-dollar verdict. New York Times appealed the case. The Supreme Court ended up with a decision that said, when you're talking about matters of major public importance and public figures, you have far more latitude in talking about them than you do on other matters, and so the idea of malice and so forth is not part of it. It really opened the door for much broader criticism, analysis, and so forth of public figures than previously existed.
Norm, how about some obscene speech, Vietnam War years, black bands, and things like that?
I can't remember the particular case. There was one real interesting case that was a freedom of speech question. It was the draft card burners, whether or not somebody as a mechanism of speech to make a particular political point could burn his or her draft card, I guess his only then at that time, his draft card, which was against, it seems kind of silly to think back on it, but it was against the law to burn your draft card or to dispose of it or to shred it or do anything with it. And as a way of political protest, the people would burn their draft cards. And that particular draft card case, there was some young boy back east was charged with the crime of doing this, and it went all the way to the Supreme Court. And the Supreme Court concluded that he indeed had committed this crime. But what the Supreme Court did, they made it so difficult to re-prosecute cases like that by their decision that no other of these draft card burning cases was ever brought again. So there was just one, went to the Supreme Court, the guy was found guilty, and then that was the end of those types of cases. And they kind of finessed that whole freedom of speech question on that particular case.
The most recent ones are the flag burning cases. There have been two of them up to the Supreme Court, a Texas statute that prohibited the burning of flag. And it's very interesting because in both instances, a very conservative Supreme Court decided by 5-4 vote that that was unconstitutional.
To deny it.
Yeah, well, that you...
the First Amendment
the statute was unconstitutional because it would punish you for burning the flag.
Yeah. Right. And we've had a couple of cases. There was the Minnesota and the Wisconsin recent cases that went to the United States Supreme Court, one right after the other on this hate crime legislation, which we're all pretty familiar with. And one of those cases says that if it's just speech alone that is directed in a hateful way towards another group, that speech is protected by the Constitution. The second case said that when speech piggybacks action, in other words, if I see a person that's a person of color and I say to my cohorts, go beat up that person, that is speech that accompanies action, and that's not protected speech. So that was kind of a clear dichotomy there, if you read those cases carefully.
Lord Marsh.
I've always been curious, when the Supreme Court or a court makes a decision which strikes down public policy, what happens now? Does that public policy become null and void, and then there's a vacuum created?
I'll tell you a case, which is Bible reading. A prayer in the schools. In 1961 or 62, the Supreme Court determined that mandatory prayer in the schools was unconstitutional, violated the right, freedom of religious rights of certain individuals. It's still very much alive. We still have school districts in our state that are doing this. The students at Post Falls last year and the year before voluntarily said we're going to have a baccalaureate ceremony. We're going to do this. This court makes the decisions, but if the people do not accept them, they go on and on and on and on, and it becomes a very difficult situation in which case keeps coming up, and we thought it was all clear, and then they do it again and again and again, and it's part of the wonders of our democracy.
And then the recourse is either to ignore it or just put up with it or pass another legislation.
That's
or policy.
right, and there are many of us who would like to ignore it all, but there are a whole lot of people who feel very passionately about that, and they will not ignore it on both sides.
I can imagine.
I would just add a footnote that in the last year, the U.S. Supreme Court also came back with another case dealing with invocations and so forth. And so sometimes there is a follow-up, a supplement, or an amendment, or even revision. We saw that so in Roe v. Wade too, right, where there is some qualification of the original decision.
Absolutely.
Right. There was in the religious area. The Supreme Court has finessed a lot of this area. And how they do that, in this one case, they had somebody had habitually for years and years put out a scene of the manger and the three wise men, and somebody for some reason objected to that and said that that's a religious expression in a public place, and on and on. And the Supreme Court said, well, it's been there so many years, it really isn't religious anymore, it's just a secular way of getting through the December holidays. So they took a totally religious expression of faith, the Christian faith, and said it wasn't an expression of Christian faith anymore. It was just a thing out there, and it's very pretty and nice. And so they could do it. That was kind of an
Let's move
interesting way
into it. Excuse me.
No, that's all I had to say.
There's also a lot of interest in discussion where we see a lot of tension to U.S. Supreme Court decisions and federal court decisions, but also state courts are very active in dealing with the state constitution and also federal questions. Here in Idaho, Norm, I'll start with you. Would you like to mention anything other than the Reed case that you talked about of decisions that you think are impacting, or here in the Northwest, in Oregon or Washington, that's been of great significance that has impact later on even the federal courts?
Well, I think Scott's case that he had an experience with in Boundary County is probably one of the most significant.
Let's move and let Scott deal with that.
Yeah, go ahead, Scott.
Oh, this is the
We have
that's,
about 2
that's
minutes.
a trial court case, and this has to do with whether the counties can tell the federal government how to run their land policies.
And so that has been through the district court, and it's on appeal now. Is my
Apparently,
understanding. Yeah. But that's another form of impacting policy.
But if we're talking, I think we should really confine our discussion to what's a little bit higher, because that one's still pending. But let me give you an example, if I can, which I was involved in that one too, which is the public trust case. In our state, it's Kootenai Environmental Alliance versus Panhandle Yacht Club. And the interesting part about it, if you are kind of a person who likes to score cases according to who's ahead and who won, we lost the case. I represented the environmental interest. We lost the case, but the case established the public trust doctrine in the state of Idaho, picking it up from other states, which says that all public bodies of water and all public lands underneath them must be administered in the public interest, and you cannot simply peddle them and sell them and give them away. And so though we lost the case, I think we won the principle, and it's still around and pervasive and getting stronger. But it's purely judge-made law. There isn't anything out there that you can find by statute or constitution or anything that identifies this.
We're right now almost out of time, but I want us to get a note that's maybe we shouldn't even end on because we don't have enough time. But also there was a very famous case from the state of Washington that went to the U.S. Supreme Court from Washington State University, and what they decided, what the state of Washington decided was very different. It's the Chrisman case, in which the final conclusion is that a state constitution, a state court, they're bound by the U.S. Constitution in rights, but they can go beyond those rights to give greater rights, but not less rights. And so I wish we had time to move into that, but maybe we'll have you back on the show at another series at another time. Gentlemen, thank you both for being with us, and I thank the panel for their fine questions. Ladies and gentlemen, we have been discussing with you today our series called Know the Law, and this particular program was The Law and Public Policy. I would like to invite you to be with us again next week at this same time. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.